Nigeria's journey towards the 2027 general elections has in many ways already begun. While the ballots are still some distance away, the political groundwork is being laid in boardrooms, at party secretariats, and across communities nationwide. The last 48 hours have been really interesting as the political calculations and permutations reach fever pitch, with alliances emerging and crashing as soon as the actors leave the scene. The governor of Bauchi State, Bala Mohammed, who is one of the only two remaining PDP governors, has come under intense pressure by both the ADC and the APC to have him join their ranks. This has become imperative as it is only a matter of time before Bala Mohammed jumps out of the fast-sinking PDP boat. Indeed, the lifeboat offered by the rebuilding efforts of the FCT Minister Nyesom Wike does not look likely to accommodate the Bauchi governor. As after an ADC delegation led by former secretary to the government of the Federation, Babachi Rulawa, left Bauchi, an APC delegation led by the national chairman, Professor Nentawe Iwada, stormed Bauchi in an operation to also persuade the Bauchi governor that their party offers the best hope for him. Now, all of these are coming on the back of the recent conventions by the APC and the PDP, events described as more than routine political exercises, but early moves in what is suspected to be a complex and highly competitive electoral cycle. Yet, the spotlight is now shifting to other political platforms like the ADC, Labour Party, SDP, and a host of smaller parties whose internal cohesion, leadership structures, and strategic direction will significantly influence the breadth and depth of political contestation in 2027. Will they emerge as credible alternatives capable of reshaping Nigeria's political space, or will familiar patterns of fragmentation and weak institutional capacity persist? Beyond party activities, however, lies a more fundamental conversation about the issues that will ultimately define the 2027 elections. Nigeria continues to grapple with persistent economic challenges, rising cost of living, unemployment, and currency instability. At the same time, concerns over national security, governance efficiency, corruption, and public trust in institutions remain central to national discourse. Increasingly, there is also a growing demand, especially among young Nigerians, for transparency, inclusion, and leadership that reflects both competence and integrity. Another critical layer to this conversation is the integrity of the electoral process itself. Questions around electoral reforms, the role of technology, the independence of institutions, and the management of election logistics will play a decisive role in shaping public confidence. The lessons from previous elections, both their successes and shortcomings, will undoubtedly influence how stakeholders prepare for what lies ahead. But perhaps the most important variable in this equation is the Nigerian people. Democracy is not sustained by political parties alone. It thrives on the active participation and responsible conduct of citizens. As we approach 2027, Nigerians are once again confronted with key responsibilities to engage critically and thoughtfully before the elections to uphold peace, vigilance, and lawful conduct during the voting process, and to demonstrate maturity and respect for democratic principles in the aftermath of the results. George Itodo is a barrister at law and a member of the African Democratic Congress, ADC. He joins us today on Jigsaw.
A very warm welcome to you. The program is Jigsaw. My name is Bega Aruleba. Indeed, George Itodo has joined us for today's discussions. George is an Abuja-based legal practitioner. But he's also a member of the ADC, that's the African Democratic Congress. Registered or on the sideline?
Registered.
Registered card carry member?
Yes, card carry member.
So are you sure that if we open the digital register of the ADC now, your name will be there?
Conspicuously there.
So if your name is there conspicuously, that means you should be abreast of the developments in your party today.
Of course.
Let's just also let you know from here that anytime from now, leaders of the ADC will be addressing newsmen here in Abuja, in a swift response to the Thunderbolt, or will I say a Tomahawk missile fired from INEC headquarters yesterday in the direction of the ADC and didn't miss target. As a party, hoping to get out of this serious quagmire.
It is really not an issue. It's
really
not an issue. Yes, I have my reasons.
Okay,
because
let us know.
What INEC did yesterday, it's actually in contempt of the Court of Appeal.
How so?
Yes, the Court of Appeal. If you look at that ruling, held that status quo's antebellum be held.
Yes.
The question is, the head of INEC is an SCN and at the same time a professor, who ordinarily ought to have understood or understand what it means.
Isn't that the reason why everybody is saying that INEC is right? Because as a senior advocate of Nigeria, he also would have read that order in and out.
Yes.
So,
balloon means war.
Antebellum, before the war.
What is war in litigation? War is when a party goes to court. That's when it's deemed that war has begun.
Really?
Yes.
War will not be when the action that gave rise to that litigation.
No. There's a difference between antebellum and anti-Jews ad bellum.
Well, you are adding to my knowledge of the law now. Before now, I knew just two. Status quo, antebellum.
Yes.
Those were the only two I knew. Status quo means as at today.
As at today.
Maintain that status.
Yes.
Antebellum means before the breakout of hostilities.
No.
Are you sure?
Yes. Before the commencement of the litigation.
What is bellum?
Bellum means war, literally. But what it means?
Before the breakout of hostilities. Hostilities is the war.
It's the war.
Yes.
When the breakout here, assuming I'm to go with you, the breakout here is the court process.
Would that be the breakout
that is when it is deemed that there is war. There could be right to war.
Before it.
Yeah, see, there's a difference between when the cause of action arises and when issues are joined, or when issues are joined, when war has begun.
Okay.
Let
me get to it. There's a difference between when the cause of action
arises.
Okay, so the cause of action here is what?
The cause of action here.
Between Nofio.
Yes.
And Senator Mark.
Yes.
When did the cause of action begin?
The cause of action, the cause of action begin from wherever
Balanofio
found it, became aggrieved.
That's when the cause of action started.
Yeah, when he became aggrieved. And remember, in this case, he has not even basis here because
Is it when he became aggrieved or the reasons leading to him being aggrieved?
No. In this case, it's when he's becoming aggrieved. Let me explain it to you.
Okay.
Ordinarily, it ought to have been reason, but in this case, he signed a letter resigning.
So he said he didn't.
He didn't. The letter is there. It's an exhibit for the court.
Which is see, that's why a lot of people are blaming David Mark and co for bringing this upon themselves. A man was in an executive of a party.
Yes.
One man from the executive decided to sell the party to some outsiders who were not even card-carrying members of the party. Adegbeshola was never a member of the ADC until that time. Senator David Mark was not. Rufai was not. Who else? Alhaji Bolaji Abdullahi was not. All of those members who are today the face of the ADC were not members of the ADC. Not to talk of being members of the executive. They were not members of the party. And then something happened. They came. They had an agreement with Ralph Okewosu. Maybe they said there was NWC that allowed them to resign and then hand over to David Mark and co. The question is, this man was a member of the NWC. Yes. He said he never resigned. And that's why he went to court, that if the chairman has resigned, so be it. But me, I've not resigned. And if the chairman has resigned, it has only worked in my favor because it then means there's a vacancy, which I ordinarily should assume.
See,
that's his claim.
if you look at the circumstances around it, you should know that he's just recanting. Look at the
How
gap.
so?
Look at the gap between when he filed his suit and the time upon which ADC was restructured, and the persons in question assumed leadership of the party. This is just a political motivated steps and evil theatrics on the part of Mr. Bala, because if you were aggrieved, you knew the party was going through restructuring. The party was going to restructure. You never read the protest. You were there. The party restructured. You never took any step until, of course, you said he was not being approached by members of the ruling party and influenced, motivated.
What happened in July? Is that what you call restructuring?
I call it restructuring.
Or you just sold out the party to some bidders?
That is restructuring.
Because if you say restructuring, how come not a single member of the RAF Owosu led national executive as at that time,
yes,
or National Working Committee, was found worthy to be retained?
There could be total restructuring.
And then in the States,
nobody resigned on the point of Durex. Nobody resigned on the gunpoint. There could be total restructuring.
That's what
restructuring may be partial, it may be total. In this case, there was a total restructuring of the party. And he was there. He knew there was going to be restructuring. He knew the day the restructuring took place. He never took any step. He waited.
He went to court.
He didn't
went to court.
Look at there's a big timeline between the time he went to court
exactly.
and the time he restructured.
So if you thought that this man, I keep forgetting his name, Nafiu Bala Gombe.
Yes.
If David Mark and co thought that Nafiu Bala Gombe slept on his right for 2 months or so before heading for the courts.
No.
It's about that, because you took over in July.
Yes.
He went to court in, was it September? In September.
Yes.
So if he slept over his right for like 2 months or a little over 2 months.
Yes.
Those were points that you should have canvassed when he went to court.
Those points are canvassed. They are in court. Remember, the matter is still in court.
That's where I'm leading to. He filed 2 processes in court. He filed one asking for, he filed a motion ex parte to stop David Mark and co from taking over and to restrain INEC from recognizing them.
Yes.
Ex parte. Then he also filed a motion of notice,
yes,
which will allow you people to come and be joined.
Yes.
But the court, rightly, Justice Whittle, rightly, when the motion ex parte came up, he could easily have granted it, but he didn't. He said, put them on notice.
Yes.
Put David Mark, INEC, and everybody on notice.
Yes.
And let them come before me,
yes,
and canvass their points.
Yes.
At that point, why did David Mark and co not deem it fit that this is the point, this is the junction where we need to stop Bala Gombe? Yeah,
at that point.
But you didn't do that. David Mark and co didn't do that. They decided to run to the Court of Appeal to appeal that interim order that Justice Whittle gave. We didn't affect them in any way. He simply said, go and invite them to come. That's what Whittle said. He didn't restrain them. So why didn't they come and then canvass all those points we are raising now instead of running to the Court of Appeal?
No. The issue is here.
That's what happened. I just recounted to you what led us to where we are now. Yeah. David Mark didn't go to challenge that interim hearing because it's just a hearing. There was no order by Justice Whittle. There's no order by him. He only said, I am putting everybody on notice. Go and serve the papers on them. Let everybody come.
See, there's something you are not getting right here. Even the Court of Appeals ruling, yes, in this case has not done any damage to ADC. As it is today, it's INEC that is doing the damage.
How so?
How so? Because INEC have violated the Court of Appeal directive.
How?
Court of Appeal said maintain status quo ante-bellum before.
Yeah.
Now,
ante-bellum that you and I now have not agreed on.
No.
We still need to go back to that point.
No, I'm telling you, I just differentiated between ante-bellum and anti-jus ad bellum.
What is anti-jus?
The right when the right anti-jus ad bellum, when the right to war accrue. And when the war had begun. That's why
So at what point would you think the war began?
the moment he went to court. Because assuming he didn't
Not
go to court.
the moment you people came and swept everybody aside.
That is when his right to
I mean,
go.
it's like you went to somebody's house. You have been admiring somebody's house. You went there. Luckily for you, the head of the house allowed you in and decided to hand over the keys to the house to you, including keys to his own bedroom, master bedroom. He handed it over to you. Then the keys to all the other rooms belonging to other members of the family, he handed them over to you. And then a member of the family who felt aggrieved that, no, you can't hand over the key to my own room to anybody, decided to go to court. It's broke out.
No. You remember, he may also he may decide not to go to court. What only begins when he had gone to court. I was recognized chairman before then, David Mark. And remember, said, don't do anything to undermine the matter before the Justice Wute. That was the Court of Appeal.
Exactly.
Now,
so now you have made very valid
Let me
points.
explain it.
Yes.
One of the orders there is that to stop INEC from further recognizing David Mark.
Would that be the damage that the Court of Appeal is talking about?
Let me tell you. Now, the matter before Justice Wute is to restrain INEC. Now, INEC on their own, without the court deciding on that matters, they recognize David Mark.
Let me read. I can't hear that. All right. We need to take a quick break just to make things right. We'll be right back.
The stories now break online. Don't miss anything from our real-time updates and exclusive content. Follow and participate in discussions on live TV studio programs to shape the narratives. Subscribe, engage, and share from AIT.live at AIT_online on X, AIT Online on Facebook, Official AIT Live on Instagram, TikTok, and Threads on YouTube. Stay connected with AIT. On air, online, on live. The stories now break online. Don't miss anything from our real-time updates and exclusive content. Follow and participate in discussions on live TV studio programs to shape the narratives. Subscribe, engage, and share from AIT.live at AIT_online on X, AIT Online on Facebook, Official AIT Live on Instagram, TikTok, and Threads on YouTube. Stay connected with AIT. On air, online, on live.
Okay, let me restate again that leaders of the ADC are holding a press conference in Abuja this afternoon to have a quick response to the INEC's decision yesterday not to recognize both the David Mark-led National Working Committee of the ADC and the Balagombe faction that is also asking INEC to recognize it. That press conference we'll be holding anytime from now, and we intend to transmit proceedings from there live. Once we get signals from there, we will take you there to join our colleagues there. Yes, I was going to read the order of the Court of Appeal. Good. Let me read. Orders of the Court of Appeal. That judgment was dated 12th of March, right?
Yes.
We're on the same page on that?
Yes, we are.
Good. It says, finally, it is necessary to make preservatory orders.
Preservatory?
Preservatory?
Yes.
So what is the court preserving?
The suit before the Federal High Court.
Okay.
So
what is the claim in that suit?
The claim in that suit is to restrain INEC from further recognizing David Mark. By the time, now this suit have not been heard, INEC on its sumo on their own have de-recognized David Mark. INEC had made futile
was it asking for further recognition of David Mark or recognition of David Mark?
He said recognition and further recognition. Because at the time
recognition is hinged on the fact that they were not lawfully installed.
No, because
there was no lawful
at the time
transition.
he went to court,
yes.
INEC recognizes David Mark as the chairman of the party. And at the time he went to court, INEC had recognized David Mark as chairman of the party. He's now in court, asking the court to restrain INEC from recognizing or further recognizing David Mark. And now INEC, without hearing of the matter, without judgment of the matter, INEC went on their own in violation and contempt of the Court of Appeal to undermine the matter before the Federal High Court by recognizing or not recognizing David Mark as the chairman of ADC. It's INEC that have acted in contempt here. It is not the court. Neither is it the party. It is INEC. Because I said preserve the suit. Because
there are so many letters. INEC was bombarded from all sides with so many letters from David Mark's lawyers, Suleiman Usman, SAN, and then from Summit Chambers, that's the law firm that handled the case for Balagombe. And there were counterclaims, seizing recognition of Senator David Mark. Okay, that's what we are saying, that INEC had previously, prior to this, recognized David Mark. So, seizing recognition. The Court of Appeal said, preserve but the Court of Appeal says, finally, it is necessary. Let me read it, maybe we'll get to that point. Finally, it is necessary to make preservatory orders to ensure that the subject matter of the dispute pending before the trial court is not prejudiced. It's not prejudiced. The subject matter. The subject matter, yes. You said the subject matter is not about who is lawfully in charge of ADC. Wouldn't that be the subject matter? That is subject matter. Exactly. So the court said, finally, it is necessary to make preservatory order to ensure that the subject matter. So you agree that the subject matter is... Let me explain this to you. He's aggrieved. He went to court. I'm looking for these orders from the court. That is the subject matter. Yes. Now, INEC granted those orders even without hearing. Let me read what the court said. Yes. Finally, it is necessary to make preservatory orders to ensure that the subject matter of the dispute pending before the trial court is not prejudiced. Yes. As courts have inherent powers to control and regulate proceedings to ensure justice. Yes. Accordingly, in order to protect the integrity of the proceedings, God bless you. And the eventual determination of the substantive suit pending before the Federal High Court is suit that the suit number B and is hereby granted accelerated hearing. Yes. So the Court of Appeal is conscious of the fact that there's a pending issue not yet looked at by the Federal High Court. God bless you. And those are the issues that INEC has resolved without the Federal High Court even determining the matter. Now, let me ask you a question. No, INEC has not determined it. INEC is simply obeying that court order. No court order. No court order. I said recognize that the parties are hereby directed to maintain the status quo ante bellum and shall refrain from taking any step or doing any act capable of fostering a fait accompli. Yes. Now, let me ask you a question. Fait accompli here should be always. It should be fait accompli as it regards the plaintiff in the case. No, fait accompli. And fait accompli as it regards the defendant. No, fait accompli as regards to the matter before the court. So what is the matter? Nofil says that these people are not known to the party. Yes. If the chairman has resigned, I, as a surviving vice chairman, national vice chairman, should be the one to step in. The subject matter. That's the issue. No, the subject matter here is that INEC recognizes David Mark as the chairman of the party. And he has gone to court to restrain INEC. For the person who went to court, that would not be the subject matter. No, that is it. The subject matter will be his own claim that I ought to be the national chairman. But have you seen his prayers in his motion that INEC should stop recognizing? Assuming INEC did not recognize David Mark, would he have gone to court? Again, the answer is no. Again, as a lawyer, yes. Do you agree with the postulation I made much earlier on that when this case was first heard by Justice Whitty, and wisely and rightly, he did not accede to the request to stop David Mark and Co from parading themselves. Okay. Instead, he said, go and serve the court papers on them so that they can come before me. Don't think that the judge knew what he was doing. He wanted David Mark and Co to come and canvass all the points so that he will be able to take an informed decision. But your colleagues, your national leader, didn't do that. They instead went to the Court of Appeal.
Yes.
Do you agree that that was a wrong move?
I may not come to the conclusion that the appeal was...
It doesn't appear smart.
No, the appeal... I don't know. You only say that they appear smart if they have gotten judgment contrary to their interest from the Court of Appeal. That is not the case here. It is INEC that is applying it contrary to their interest. There's something... You have come to the conclusion that that order means that they should go back to when cause of action arose. No! Before war begins means when the matter is in court. Don't do any act that undermines the court. Assuming INEC has recognized David Mark. Tell me, what is the man still doing in court? Because the essence he went to court was from arresting INEC from recognizing David Mark. INEC did not wait for the determination of that matter when they had to, on their own, consider their own panel and they recognized David Mark. Then what is he doing in the court? So
why did David Mark rush to the Court of Appeal? Because the lower court had not granted any order restraining him. Why did he rush to the Court of Appeal? Instead of coming before that court, because the court had not tampered with his status as at that time.
Yes.
Because it was a course of action that led to this, to INEC either being misguided or misdirected itself right now. Because if he had not gone to Court of Appeal, there would have been no order of whether it is anti-Balloon, anti-Easter Balloon, or whatever other things that goes added to it.
It's an insult to the personality of the INEC chairman, being a professor and an SCN, to say that that order misled him. He's an SCN, for God's sake.
No, you have not responded to the issue I was...
No, you said
if David Mark had not gone to the Court of Appeal,
or whatever.
If David Mark had not gone to the Court of Appeal, and he has simply received the summons that the court said, go and serve this summons on him, so that he can come and canvass his own defense.
Yes.
If he had simply obeyed that, the Court of Appeal, the lower court would have had that case, probably dismiss it, or probably grant it. In which case, there's concrete issue before the Court of Appeal.
Okay.
But as it is now, there's no concrete issue before the Court of Appeal, and there's also no concrete decision by the lower court. So, as it were, David Mark has been bossed to a corner, either by a misinterpretation of the directive of the Court of Appeal.
No, by mischievous theater.
You are the one saying that. I'm not a politician.
I can tell you that. I can tell you that. See, there's no basis of INEC misunderstanding that order.
No, but do you agree that if that David Mark's decision to go to Court of Appeal wasn't the right thing at that particular thing to do? Because there was nothing to go to Court of Appeal to do. The lower court had not issued any injunction against you.
I didn't know. Okay.
Is it that when there's an order against you that you go to Court of Appeal to set this aside? There was no order against him. There was no order. If any order at all, the order is that serve the papers on them. Since they are the ones who want to get injunction again, serve the court papers on them so that everybody can come before me.
I can't comment.
That is not an adverse order against you. That wasn't an adverse order.
I am not the lawyer.
You were not part of the legal team.
I don't know the basis. I know no lawyer
for which you went to Court of Appeal.
I can't tell you.
But if you are not appearing for any of the parties, would you agree with me that that wasn't
I don't know the fact that transpired. I'm just hearing from you the fact that actually transpired leading to the appeal. What was sensed, there must have been fact who may have transpired at the lower court that may have led to the Court of Appeal.
There was nothing.
What I'm telling you
all
here,
that led to the Court of Appeal proceedings is David Mark's action to run to the Court of Appeal to drag the matter there.
Yes, and in this case...
And it was predicated on nothing. Because, like I said, there was no adverse order against him to INEC.
Now, is there any adverse order?
And INEC continued to recognize him until the Court of Appeal on the 12th of March gave this position.
No, INEC...
Continued to recognize David Mark. That's what I'm saying. Until this order. So there was nothing for him to run to the Court of Appeal for.
What I'm telling you, there's nothing in this order necessitating INEC from recognizing David. As a matter of fact, this order preserved the seat of David Mark pending the hearing of that matter. INEC are in contempt, and clearly in contempt of the Court of Appeal. They say, preserve the subject matter. This guy went to court, for God's sake, to restrain INEC from recognizing David Mark. And INEC, without waiting for the Federal High Court to hear and determine the matter, as to whether to restrain whatever, INEC on their own derecognize David Mark, thereby undermining the matter before the Federal High Court. That's what I'm talking about. There's nothing here affecting our adversarial to David Mark. It is INEC that is acting in contempt. There's more of a political manipulated whatever. You know, there's no basis for INEC to even. Even an elementary law student would know that that law cannot be misunderstood to the point where you stop recognizing INEC. The essence of being in federal court is the recognition of David Mark. And the Court of Appeal said, preserve that suit, which means then he granted antebellum. He was the chairman before the guy went to court.
That's your interpretation.
No,
some others may interpret it differently.
No.
Like the way I had been interpreting it to mean that it's what gave cause to the court action is the fact that Nofiu was edged out of what he thought was rightfully his, which is that if whether he was settled and he had started
Court of Appeal cannot
abandon,
make that kind of order. Court of Appeal cannot say remain there before the call of action arose. It's like granting the prayers of the plaintiff even before being heard. Before he went to court, this is the state of things. Okay, hold it there. When we hear, we don't know whether this person sitting down there ought to be there or not. Then
which was why the Court of Appeal ordered accelerated hearing.
Yes,
the Court of Appeal probably thought that this party is in crisis because, as it is now, there's nobody in charge. One who has been paid off is left. No other person was left there.
I don't know about paid off. But I don't know about payoff.
Don't mind me.
But I'm telling you about restructuring. Now, what INEC needed to do, since there's an accelerated hearing, is to hold on. There'll be hearing, there'll be judgment. Why are they in a hurry?
Again, that's what I'm saying, that probably that's why the Court of Appeal ordered accelerated hearing of
yes,
that whatever it is that this man is claiming, please hear him speedily, because as things are now, nobody is in charge in ADC. But you are saying it is not that nobody is in charge, it is that the wrong person, in the opinion of Nofiu, were in charge, and in your opinion, the right persons following a restructuring have taken over. That's your interpretation. No. Get my point clear.
Don't twist me here. Now, Mr. Gwega, don't twist me here. What I am saying is this. Nofiu had gone to court.
Yes.
Court of Appeal said, yes, here is matter accelerated. However, maintain status quo. If Court of Appeal said, no, don't recognize David Mark, it means that Court of Appeal had granted his prayers even before the trial court, which Court of Appeal would not.
Okay, let's conclude on this issue. Yes. If you are... I know the ADC is not bereft or bereaved of quality legal advice, but let us assume that we are mixing law and politics together now to get a good mix. Okay. What will you, beyond all this, is the APC that is doing this, INEC is acting the script of APC and all of that, those are non-issues, really. You're just wasting time. Concretely, what would you advise David Mark and co. to do? Beyond all these wild allegations that it is the APC that is behind all of this. Because at all material times, Nofiu is not a member of the APC. At all material times, he was a national officer of ADC. At all material...
Before he resigned, not all material time, before his resignation.
He said he never did. So if he resigned, instead of David Mark rushing to the Court of Appeal, are those not the things he would bring to the court, to Justice Iwite's court, and say, my lord, don't listen to this impostor. He wants to reap where he has not sown. No. See his letter of resignation. He resigned.
Of course.
He didn't do that. If it's true that Nofiu resigned and you people believe he resigned, that's what you should have done instead of running to Court of Appeal.
No, there are joint issues. Of course, even if you are appealing, even if you are challenging jurisdiction, you still join issues. There are joint issues there. The letter is before the court.
So simply because Justice Iwite, just listen to him. You are already raising the issue of jurisdiction. I ought not to have listened to him at all. That's why you ran to Court of Appeal.
Okay. I ought
not to have listened to him at all.
Yes, probably.
Is that the law?
No. It depends on the... Like I told you, I'm not the lawyer handling the matter. I don't know the facts, the circumstances, or whatever that would have warranted the going to appeal. And I can't condemn it from here, then I cannot approve it from here. I don't know the fact that transpired in our appeal. What we're talking about, what we are, me and you are deliberating on, the order, the white paper order before us. What does it mean? Does it warrant INEC reorganizing David Mark? The answer is no.
Okay. Beyond all of this, APC is doing us in, INEC is a student of APC, and all of that. What concretely would you advise beyond? They are going to be addressing a press conference, so we don't know. They may have outlined a course of action, but independent of that, what will you advise?
Yes,
because this situation has a lot of dire consequences, particularly for the David Mark side.
Which
Particularly for the
which has always been the motive in this matter. Which has always been the motive.
I don't know about any motive. I'm just telling you that this is a party that wants to be the major face of the opposition. So if that major face of opposition is embroiled in this kind of crisis, and we don't know how soon it's going to get out of it, and you have an election timetable that has been compressed, and there are things that are on timeline.
Illegality cannot stand for long. It will be corrected.
Is that what we advise? I'm asking, what concrete advice would you give on how to get out of this? Go back to the Court of Appeal?
Go back to interpretation.
Go back to the Court of Appeal for interpretation. Further waste of time.
Yeah, but I don't even see why this should be misunderstood.
Yeah, but it has. See, INEC has written the letter. So forget about whether INEC was right or not.
No.
INEC has taken a decision. How do we intend to work? In this case
now, INEC has acted if I was the one, INEC has acted in content of the court procedure.
So what would you do?
If I am the one, I will institute a contempt procedure against the chairman of the INEC. In this case, you have no excuse.
Don't forget that the Court of Appeal even said, I don't know whether it is ADC or INEC, that the Court of Appeal said should be paid 2 million. No?
To be paid 2 million.
In this case,
yes.
In that judgment now,
yes,
that the parties are hereby directed to maintain the status quo ante bellum and shall refrain from taking any step or doing any act capable of forcing a fate accomplished.
This is what INEC has done.
On the court or otherwise rendering nugatory the proceedings before the trial court. Cost of 2 million naira is awarded in favor of the first respondent. The first respondent, I think, is
the Gombe.
Is it Balagombe?
Yes.
See, he's making money at your expense.
No, listen to my point. Listen to my point. Yes. The mere fact that there is a cost awarded to Balagombe does not mean that INEC should
by the Court of Appeal.
Yeah, by the Court of Appeal does not mean that INEC should now go in contempt of the Court of Appeal order. Don't do any act that tempers with the proceeding before the federal
court. Could this be part of what influenced the position of INEC, that the Court of Appeal believed in this man's case?
For God's sake, INEC is headed by an SCN and a professor that shouldn't ordinarily be misled. He has no excuse to be misled. At this point in his life, honor and legacy should be more important to him. There's no reason, no basis for him to have been misled by that order.
Okay.
It is clear.
So you have only given me one point that you are canvassing now. INEC is guilty of contempt, you said?
I won't speak much for the party, but whatever the party resolves to do, it will be made known.
As a lawyer, what will you, if
as a lawyer, I just told you, I will institute contempt procedure against the INEC chairman. Yes.
And how long do you think, in a case like this, how long do you think...
Does the contempt proceedings affect... And remember...
No, how long do you think that should take? Because, like I said, everything is on timeline here.
That INEC does not...
If INEC tomorrow...
INEC is not monitoring...
For instance, INEC is considering the guidelines for the 2027 elections.
Yes.
It has already given it to the political party to go and study and make their input. If tomorrow INEC decides to call the political party, come, what do you think? What are your positions?
My joy.
They will not invite ADC.
They will not invite ADC.
Exactly.
Okay. What we have, I think we're at the stage of congresses and the rest.
That's another point.
INEC will not attend the Congress.
And if INEC does not attend, what does it mean?
It doesn't invalidate it.
Really?
Yes. What is mandatory for a party to do is to give INEC notice. Once a party has satisfied their own statutory requirement, that INEC attends or not, there's 1,000 authority to that.
Okay.
The attendance of INEC does not validate or invalidate the Congress. But what validates or what is the notice, the requirement for notice, and the compliance. Once a party has compliance with statutory obligation.
What about the fact that INEC will also not engage with any of the sides? In any communication, there will be no communications with David Mark and Aregbesola. There will be no communication with Nofiu Bala.
This is just even a waste of time, because the moment the Court of Federal High Court gives judgment, all this.
But we have not gone to the Federal High Court.
We have not gone to that. That's why I say INEC shouldn't have.
Which is what you have done.
You are now agreeing with me.
Since last year, if you had done this, the proceeding probably wouldn't have taken more than a day.
You are now agreeing with me that INEC has done something to undermine the proceeding before the court.
Okay. So shouldn't your advice therefore be how to revive the proceedings before the Federal High Court and let the Federal High Court hear what we have against Bala Gombe?
No one is stopping that.
Shouldn't that be what David Mark and Co. should be pursuing?
Of course.
As against APC's
like I told you, of course,
that
that is not left behind. Whether the Court of Appeal even granted prayers or not, that proceeding before the Federal High Court, appearance will be entered, hearings will be made, judgment will be given. No doubt on that. Judgment is going to come.
If I were you, I would be speaking directly to them now that, guys, this is what you should do. Let us get back to that Federal High Court ASAP.
Of course, ADC.
Tomorrow is public holiday, Monday is public holiday. Tuesday, we should be at the Federal High Court before Justice Witten. Whatever will enable us to be heard that day, let us prepare it now so that on Tuesday we are heard.
No one is stopping. Of course.
That's the way to go.
That's the respect to rule of which we will.
That's the way to go.
No one is stopping that. No one has said that we are not going to court. We all join.
So all these other one is just the politics of it, accusing other people who didn't know.
No. It is INEC steps. It is INEC undermining the court.
It's not just INEC that we are abusing.
No,
we are also abusing the APC.
No,
that INEC is dancing to the tune of APC.
Of course.
How so?
Of course.
Is Bala Gombe a member of APC? Was it up until July when you went there to go and take over his house? Was he not a member?
Of course,
a national officer
and he saw
of
an
the ADC?
opportunity to become a stooge.
He was a member of the ADC.
Of course, and he saw an opportunity.
You were the one who went to his house to go and you were admiring his house from afar.
He is the one who succumbed to restructuring. He signed the letter addressed to his ward.
Where is this letter?
It's there. It's there.
All right.
If I knew you needed it, I would have gotten you a copy. His signature is there. His name is there.
Maybe when you eventually come before Justice Witten,
and if he's saying those letters were forged, he knows what to do when he feels something is forged. You don't prove forgery by an affidavit evidence. You go to oral trial. Let him institute an oral trial. Then we'll get him there. He knows what he's doing.
Okay.
I'm sure he's also convinced 100% that what he's doing is wrong. But because of whatever it is, that's benefiting from it. That's why he's doing this nonsense.
All right, let's move on to another issue. Until the INEC letter yesterday, you were actually aiming for the sky with one very big fish like this in Bauchi. The Bauchi state governor, who is by and by becoming, quote unquote, homeless. You were probably happy when you dispatched that high-powered delegation to him. You were already hopeful that, if we're able to harvest Bala Mohammed into our baskets.
Like every other Nigerian, we're harvesting into our basket. We're happy.
But what you thought you did in one day, APC went the following day to undo it.
He has not made his decision. Until he made his decision, then we can now say whether we did it.
Do you think he will come to a camp where he has very few friends as against a camp where there are so many other governors who, as co-governors, they'll be rubbing shoulders together?
See, if you look at ADC's approach,
yes,
it has not been about governors. It has been about the people.
Forget about that one.
I have to address you. Now tell me, a party that has 31 governors.
Yes.
A party that has two-thirds majority.
Yeah.
A party that has found a way of manipulating the electoral act to the way they want it. We left it for them. No problem.
Which aspect of the electoral process today have they manipulated?
I'm coming. A party that has the city boys, that has the money, independent of whatever they do for a living.
What do you have against city boys?
A party that shares rice is now fighting to have just one more governor.
What's wrong in giving out palliatives?
It's now G3. But ADC is about the people. I made the last time I did an interview here.
Would you think that it's because they are G3 that they went to Bauchi State?
Of course.
Just because they thought, okay, here is a man who is going to be homeless anyway. So let's offer him... Let's offer him shelter.
By flying down to Bauchi.
Would they have trekked?
To beg him to...
Should Netawe Yitwada have trekked from Abuja to Bauchi?
You went to a man's house to say he doesn't have shelter. They should come to your own house. And you went to his house. This is funny.
So,
you came to my house and I don't have shelter. I should come and live in your house.
But you are still hopeful that you get Bala Mohammed to your side, right?
I'm hopeful. That will get majority of Nigerians on our side.
Okay, it's majority of Nigerians now.
On our side.
Okay, all right. As a lawyer, are there, because I know that the ADC, just like all, as the face of the opposition, has been picking a lot of holes in the Electoral Act of 2026.
Yes.
As a lawyer, what are your concerns about the Electoral Act? And do you think the Electoral Act 2026 isn't an improvement on the Electoral Act 2022?
How can it be an improvement?
So in what areas do you think the Electoral Act 2026 has dragged us back?
In an Electoral Act,
yes,
where you remove qualification of a candidate as grounds of challenging an election petition. Because you know one of the candidates, or you know that the head, one of the issues affecting many of them is that they are not qualified to even contest.
Why should you wait till election is held before you challenge the qualification of a candidate? Why should anybody wait till election has been held before you do that? Because if you do that, you are putting a whole lot at risk. The fact that the money spent to conduct elections, you are not considering all of that.
Okay.
If you think Benga is your opponent in an election, and you think Benga is not qualified, couldn't you have challenged it before election?
How would you
as a pre-election matter?
How would you have?
What makes it impossible?
Because in pre-election matters, it takes a member of the party or a co-aspirant to have challenged your qualification. It's not open. The only time it's open to the society, to the other party, is during the election. It's a post-election matter.
And it has now been removed as a grant for petition.
It has now been removed as a grant for petition. So how do you question the qualification? How do you question the qualification? Why are they afraid of their qualifications? Because I can't question it during pre-election because the law forbids me from questioning during pre-election. Now you remove it from post-election where the law gives me an opportunity, the other party opportunity to question it. What is there about qualification? In a reasonable society, at this level, this era...
Does it not amount to a kind of technical way of trying to cancel an election or nullify an election?
Then the man who is qualified, what is his fear? If I am qualified, whatever grammar you want to give to it, give to it. I am qualified. I am a lawyer today. My certificates are there. My origin are known. They know my father, they know my mother. So why need to be scared?
So as it were now, leaving us with substantial non-compliance with the process, with the process leading to the election is not enough ground to nullify an election for you. You still want that issue of disqualification to be added as a ground?
Assuming an imposter.
Because whoever is questioning an election now has to base it on the conduct of the election.
Yes.
The actual conduct of the election. Not anything that has happened before the election.
No.
Because qualification is something that has happened. So qualification or non-qualification is something that has happened before the...
Who leads us? The qualification, the person that leads us should not be called into question here. Ex-convict, certificate forgers, which means I can just stand up today, assuming I'm not educated, bring in a certificate that is not subject to questioning, and it will fly. Is that the kind of society we should fight for? That where I'm not qualified constitutionally because I've been a convict, either here in Nigeria or elsewhere, it should not be brought. Because we want to talk about non-compliance, we should allow all kind of personalities lead us as a nation. I don't agree with that.
There's a proposition here.
Yes.
Between making qualification a ground for election petition and removing that clog that bars just anybody from challenging somebody's qualification for an election, which would you subscribe to?
I would rather subscribe to the latter.
To it being
a pre-election matter. But
pre-election matter.
Yes, I don't have a problem with
anybody...
that. But in this case, they made it impossible.
That's what I'm saying. That would because if you are canvassing an amendment, which would you couch and submit as a proposal?
There should just be an opportunity to test
for anybody For example, if I'm not a member of that political party,
yes,
but I believe that I went to school with him now, he didn't graduate with us,
yes,
and today he's parading a certificate, and I'm in another different political party, I should be able to challenge him.
Yes.
That's what I'm saying.
Be it pre or post, any means, but there should be an opportunity for every Nigerians to test their leaders, the qualification of their leaders. What is it about that qualification that they're hiding away from? Is it because we're now expecting things that they could not come out in 2023 election to come out this time? Why are they? Because now as it is now, you know that we could not get certain conviction proceedings and all that. Assuming they come out, assuming they are out now, what they are saying is, no matter the information you have on any of the elected leader, even if you have been convicted in UK, US, whatever, even if you bring it to the court now, you know they could not get it 2023. Assuming they get it now, it now becomes inconsequential because you can no longer question whatever. That's why I say they twisted the Electoral Act to suit their whims.
Okay, but you have only pointed out one. That is, you said it's not an improvement. In actual fact, it's like taking us back to Egypt.
Taking us back to Egypt.
Instead of acquiring land in the promised land, we are going back to Egypt.
They have a lot of communication problems.
Okay, all right. So very valid observation you made there. Is there any other one?
Yeah,
what about the issue of transmission or no transmission?
That is another.
What we have now, how is it bad?
How is it bad?
Yes.
Given an alternative.
Yes. Let us assume...
To manipulate.
How?
The election. For instance...
Let us assume that instead of what is reading now in the Electoral Act, what we have is that the polling officer shall, in record time, transmit the result of a polling unit to an IREF viewing portal.
Yes.
And that's the one that has been signed. The result sheet that has been signed by everybody.
Yes.
That he shall transmit it there.
Yes.
And copies of this shall be given to agents of political parties.
At the what? Yes.
The IREF is not a collation center. When you want to collate, is it not the hard copy?
Yes.
That the collation officer will request for.
But you know...
So, is it not only when there's a dispute that you have a recourse to the IRF viewing center? Because it is not that it's every result that is given to you that you have to go to IRF to go on. It's when there's a dispute to be sure that, particularly if you suspect that, this one that has been given to you appears mutilated, there are cancellations and all of that. Could it be that the results uploaded to the IRF portal is also replete with all these cancellations? Let me find out. That's where you resort. You cannot use the IRF to collate. Because I've said this over and over that the IRF is just a viewing portal. It's like a file. It is not where collation takes place. So if that is the fact, whether or not that transmission to the IRF portal is done real time or is done where there is network, doesn't matter really. Should we have stored the process that you people were saying, unless it is put there, we can move further?
How would going to IREF, the purpose of checking the IREF is to authenticate what was actually transmitted?
If there's a dispute.
No.
Don't forget that
if there's a dispute.
Yes.
Is to ensure a free and fair election. Me and you know that a lot of things happen between polling unit and collation centers.
That's what I said, that if the collation officer is not sure, if the collation officer is not sure that something has happened to this, he goes to IRF. Through his own system, he logs in to see what is in the IRF.
You are trying to...
You cannot collate, you can't use that IRF to collate. Collation will still be manual. What
we are fighting for is an institution that survives a corrupt officer or corrupt politicians. It's an institution that, assuming the collation officer himself shows to be corrupt, the law mandates him to go back to IRF. That's why we're trying to create a structure that survives individual personalities. We've seen situations where collation officers are actually the people who come to rig those elections by writing fictitious numbers. Situation where we have such, the institution we have built, the system we have built now survives those persons. That's what we're asking for. Situation where even if you choose to be corrupt, even if you choose to do whatever you want to do, the IREV result there and there.
But as it is now, we have an election. Do you think the Electoral Act is inchoate, as it were? Because after the president has signed, the House of Representatives went back and started some other things,
yes.
And it doesn't have concurrence of the Senate. Do you think what they have done as regards that particular issue is of no effect?
Of course.
The Electoral Act we have is the one signed by the president.
It's the one was signed by the president. Until it is passed and signed by the president again, then it becomes
or until the Senate concurs with them?
No, even if the Senate concurs, it becomes an amendment. The president will have to still sign.
All right. Maybe we should just leave it here, but it's a Judge Itodo.
Thank you.
I wish you luck today.
Thank you, sir.
Thank you so much. I really appreciate your time. I've enjoyed the session with you.
Thank you, sir. Thank you, sir. The little
I like people who try to educate me.
No, but it's true. What Adek is doing is funny. It's true. Right. I didn't want to, one of the things I would not want to do.
Can we start off the program and then...
Okay.
You can, if you... yeah, we're almost done. Thank you so much. I really appreciate your time.
Thank you, sir. Thank you.
All right, that's Jigsaw for today. Our guest has been Barrister George Itodo. He's a member of the ADC. He's joined us today as we quickly key into the developments in the polity. And we told you that leaders of the ADC are gathered somewhere in Abuja now. They'll be addressing the media anytime from now. When they are ready with that event, AIT will be transmitting it live to bring the proceedings to you. Thank you for investing your time with us. We really appreciate it. Enjoy the rest of the day. I'll see you around. My name is Gbenga Aruyeba.